Well, good morning, everybody. Thank you for coming to today's probate class. Before I let instructor Georgina Lepe start, I have an announcement that I would like to make. On October 16th at 2 o'clock, we have a 1 hour question and answer session with the LA County Assessor, Jeffrey Prang. He's going to be talking to us about the propositions that affect real estate that are going to be on the ballot. He's going to explain them. He'll take questions about them, and he'll talk a little bit about too, like what will happen if they do pass, what's going to happen at the county level, how are they going to make all that work. It's going to be very informative for you. So I'm hoping that you'll be able to join us. It's going to be a Zoom webinar. Again, that's Friday, October 16th. It'll be from 2 to 3 p.m. You can go to the Tri-County's website to register. And then once you register, you'll get the Zoom information like you do for all the classes that we have. So I hope to see your lovely names there. And anyways, that's all I have. So I'm going to turn it over to Georgina.
Good morning, everyone. And actually, that seems like a great presentation. I know there's a lot of changes, so I do encourage everyone to attend. Let me share my screen with you. Okay, I think my PowerPoint is up. So today's presentation is Realtor's Guide to Probate. Just like any other presentation that I normally have at the board, I'm going to hold off on questions until the very end. So at the end of the presentation, if you have any questions, you can go ahead and submit them through the chat. And then I'll address your questions then. Just don't get ahead of yourself because if you submit your question during the presentation, it's very likely that I will address your question during this time that we have together. All right, a little bit about my office. I believe most of you have already seen me speak at the board, but my practice does focus on estate planning, probates, and real estate law. Like I mentioned, today we're going to focus on probates. I do have a presentation concerning living trust. And then with real estate law, I handle several aspects of real estate law, evictions, which are essentially non-existent right now, partition lawsuits when there are 2 or more owners of the property and one wishes to sell and the other one does not. We can actually force the sale of the property, disputes over the EMD, and breach of contract. So let's get started. What are we going to be discussing today? First and foremost, what is probate? I know there's a lot of you attending today's presentation. I really don't know, if you're familiar with probate, if you ever had a probate transaction, or you're trying to get into probate. This presentation was prepared to equip you so when you go to a listing appointment, you more or less know or are able to provide a little bit of information to the client. Obviously, you cannot give legal advice, but hopefully this presentation will assist you in your transactions, and that way you don't lose any sleep if something comes up, because you know that there is a way to resolve whatever issue you may have. And hopefully you see the problem early on, as opposed to when escrow is set to close and then you can't close because there's an issue with title. So what is probate? We're going to discuss joint tenancy, the spousal property petition, which is very popular and one of my favorite procedures, real property valued under $166,000. And no, I am not crazy. I am familiar with the housing market in California, but you will realize why you will probably use this procedure in one of your transactions. Living trust, and then at the very end, we are going to discuss the full-blown probate. Honestly, the goal is to avoid probate. I know a lot of realtors get excited and say, well, I want to be a probate realtor. I want to take probate listings, and that's great. But when you're meeting with a client, the goal is to save them money and move forward with a sale as soon as possible. So there are ways to sell a property all while avoiding the full-blown probate and be able to close on that transaction much faster. So what is probate? Probate is the court-supervised process of gathering a deceased person's assets and distributing them to the creditors and the heirs, and obviously paying the attorney and the courts. You are in the probate world when you are dealing with a deceased individual and his or her property. So if someone has passed away and they're entitled to real property, guess what? You're going to end up in probate court. Probate is necessary if a person passes away with or without a will. You as realtors may encounter situations where a potential client tells you, realtor, I want to sell my mom's house like now. She passed away yesterday, but I need this money, so I need to sell it now. But don't worry, realtor, I have my mom's will. I'm listed as the executor. That really doesn't do much. You would still have to go through the probate process to get the person appointed. So just because someone has a will, they nominate someone as the executor, that does not give them the authority to sign your listing agreement. So just remember, someone passes away with or without a will, you have to go through the entire probate process. This last bullet point is very important. You may end up in probate court, but you may not necessarily have a probate transaction. Why is this important? If you have a probate transaction, there are certain forms that you need to use. Obviously, the probate purchase agreement. However, there are cases where we will go in and out of probate court and you will not have a probate transaction, meaning you will use the standard RPA. You do not need to use the probate purchase agreement. You don't have to worry about court confirmation and those other terms that you normally use when you have a probate transaction. Why do you want to avoid probate? One of the reasons is the attorney's fees. We as attorneys get paid a percentage of the entire value of the estate. It doesn't really matter how much equity the home has. All we are looking at, what is the market value? So if we're dealing with one home and that one home is worth $500,000, the attorney will receive at least $13,000. And the reason I say at least is we have the right to petition the court, to request the court for them to increase our statutory fee. The personal representative, the family member that assists the attorney, is entitled to the same amount, the same exact amount as the attorney, without even going to law school, without having to study 14 hours a day for 2 months for the bar exam. They still get the same amount. So 13 plus 13 is $26,000. So just to probate one home worth $500,000, the statutory attorney and personal representative fee would be at least $26,000. Let's assume the court bumps up the attorney fee. This number can easily be $30,000. In addition to these fees, you have court filing fees. You open the door to creditors. When we initiate a probate proceeding, we have to publish it in the newspaper. So if there's anyone that the decedent owed money to, they can file a claim in the probate proceeding. This is a big one, Medi-Cal. By law, when we initiate a probate proceeding and our client gets appointed as a personal representative, we need to notify Medi-Cal. So if any money is owed to Medi-Cal, Medi-Cal can file a claim. And they're not going to file a claim for 50 cents. No, with Medi-Cal, the sky is the limit. So whatever benefit they conveyed to the decedent, that's going to be their amount of the claim. I've had cases where the claim is $150,000. So we're not talking about pennies, it's thousands of dollars. Creditor claims, if the decedent owed any money to credit card companies, well, first we need to provide notice to them, and then second, they have the opportunity to file claims. I have probate cases where there's like 20, 30 claims filed by different credit card companies. So who gets paid first? Obviously the court, the attorney, the personal representative. The creditor claims are paid off, Medi-Cal claims, and at the very end, if there's any money left, then that goes to the heirs. And now, post-COVID, it's going to take a long time to close out these probate proceedings. prior to COVID, it would take us about 1.5 years, assuming we moved everything super fast. Now, easily, I think to close out a probate, I wouldn't be surprised if it would take us 3 years. So this is the reason why you want to avoid probate. The first scenario we're going to discuss is joint tenancy. This is not a probate transaction so long as you have one living owner on title. So let's assume you go to a listing appointment. At that appointment, the person that you have in front of you tells you, "Realtor, my husband just died. He's on title with me. I want to sell this property." Initially, you may think, well, there's a deceased person on title. They want to sell. This is a probate. Hold your horses. The very first thing you need to do is check vesting. What does it say after the names of the owners? What is the vesting? If vesting is as joint tenants or joint tenants with the right of survivorship, husband and wife as community property, husband and wife with the right of survivorship. If vesting is in any of those ways, and you have one living person on title, you will avoid probate. All that needs to be done is that the deceased individual needs to be removed from title. And you normally do that with an affidavit. In that affidavit, you indicate attached is the death certificate of this person. They have passed away. So it automatically goes to the surviving joint owners. The issue that you may encounter here is that the living person, the person that's still on title, they need to have capacity to sign. They need to have capacity to understand the legal implications of your contract, because your listing agreement is a contract. When they accept an offer, that's a contract. So if the person doesn't have capacity, you're kind of stuck. Obviously, there's two ways around that. One would be if there's a financial power of attorney that allows someone else to act on behalf of the person that lacks capacity, and it includes the power to sell. Or secondly, the other option would be to file a petition for a conservatorship, where a court will appoint a family member to make financial decisions for the person. Obviously, a conservatorship is very expensive. If the person that's listed on title lacks capacity and they want to sell the property using a financial power of attorney, so let's say I'm the surviving owner on title and I lack capacity, and my daughter has approached you and tells you, "Realtor, my mom has a financial power of attorney. She's nominated me as her agent. I want to proceed and sign your listing agreement and sell this property." Before you get too excited, you as the realtor should send that financial power of attorney to your title officer to confirm that you will be able to close that transaction using that financial power of attorney. I would hate for you to go through all the motions of, opening up escrow, the buyer doing their inspections, and at the 11th hour, the title company says, "Wait, we don't like this power of attorney. It has coffee stains all over. It has grease marks. So no, we don't know when this power of attorney was signed. We don't want to assume responsibility for it. We're not going to honor that power of attorney." Obviously, each title company is different as to the amount of risk they're willing to take. So you can always switch title companies. Normally, the escrow company can complete the affidavit of death of joint tenant to remove the decedent from title. Like I mentioned, you will need a certified copy of the death certificate. Time frame for removal: immediately upon recording. So sometimes it's done concurrently. The affidavit and the deed selling the property will be recorded at the same time. Like I said, the title company can record it after the escrow company has prepared it. This is a cutout of the affidavit of death of joint tenancy. All you're indicating, the person listed in the attached death certificate has passed away. They acquire title as a joint tenant with the other living person. Any person of age and with knowledge can complete this affidavit of death of joint tenancy. It doesn't necessarily have to be the other owner that's still alive. It can be anyone with knowledge, so long as that they're an adult. The second option is the spousal property petition. So assuming that there's vesting is not as joint tenants, or it's not as husband and wife as community property, and we have to go through probate, this is a probate procedure. We're in and out of probate court, but you do not have a probate transaction, meaning you do not have to use the probate purchase agreement. So what are the requirements? Well, this is the fact pattern. You go to a listing appointment. The client, that person that you have in front of you, tells you, realtor, I want to sell this property, but my husband or wife was the only one on title, and now they have passed away. So at that point, you start thinking, okay, this is a probate because the deceased individual is on title, and he or her is the only one on title. With this summary probate procedure, we are able to transfer ownership of the property to the surviving spouse without doing the full-blown probate, without, having to pay thousands of dollars in statutory attorney's fees. But here are the requirements. The deceased is survived by the spouse. And the reason this is in bold, underlined, and red, this is the most important requirement. The parties must have been married. California does not acknowledge common law marriages, meaning if you've been living together with your significant other for 40 years and you never got married, yet you refer to your significant other as your boo, your husband, your wifey, they're not your spouse. You're not married. It doesn't matter how many kids you have to be legally married. So a question for you to ask your client is, were you married? And if so, when did you get married? The second requirement is that the property is community property. So what is community property? Anything that is acquired during marriage is presumed to be a community asset. So let's assume that the parties got married in 1980 and they purchased the home in 1985. Well, that is presumed to be a community asset because it was acquired during marriage. Obviously, you have to inquire a little bit more to find out what money was used to purchase that home. If the decedent used his inheritance, which is a sole and separate property, to purchase his property, then that presumption is rebutted and it's not a community asset. So the courts will want some type of evidence that shows that it's a community asset. What funds were used to purchase the property? There's no will disposing part of the property to another person besides the surviving spouse. The majority of the time, there's not going to be a will. There's not going to be anything. Someone died suddenly, and so they didn't have an opportunity to sit down with an attorney or with LegalZoom to create their will. So long as there's no will, you're okay. If there's a will saying everything goes to my spouse, you're still good. Last requirement, there's no agreement between the parties that affects the disposition of the property. What do I mean by this? There's no prenup, there's no post-marital agreement, there's nothing. So if all these requirements are met, the judge will approve ownership to be transferred into the name of the surviving spouse. Basically, what we're alleging with this spousal property petition is as follows. I and the decedent were married. During our marriage, we acquired this property, but for whatever reason, title was just taken out in the decedent's name. Maybe I had bad credit, maybe I had too many debts in my name, maybe we obtained a better rate if only husband or wife went on title, so that is the reason. Now, husband has passed away or wife, his 50 or her 50% goes to me because I am his or her spouse and we live in a community property state. So my spouse's 50% goes to me because I am the other surviving spouse. And the other 50% is mine because we acquired it during marriage with community assets. So it's a community property. So it's mine. 50 plus 50 equals 100. And this is sort of the procedure. We file the petition. The hearing is set anywhere from 6 weeks to 5 months out. We mail out notices. We attend the hearing. If there's no objections, the order is signed. So now we file the certified order with the recorder's office, and the surviving spouse is now the owner of the property. Even though we had to go through a summary probate procedure, this is not a probate transaction. The surviving spouse is now the sole owner of this property, and he or she can do as they please with this property. You can also use this procedure if husband and wife took title as tenants in common, or if there's no vesting. Because remember, if vesting is as joint tenants or husband and wife as community property, upon the passing of one of them, it goes to the surviving spouse. But if vesting is as tenants in common, meaning husband and wife as tenants in common, you still have to probate the decedent spouse's interest in that property. So you can use this procedure. Or if there's no vesting, or if just the decedent is on title. Here's a breakdown of the timeframes for each county. Keep in mind that these timeframes may be a bit off now due to COVID. The courts were closed for about 3 months, so that did affect their calendaring system, and they're very behind on all their cases. The only differences I would like to point out is that in San Bernardino and Riverside County, I can actually walk out of the courtroom with a signed order the day of the hearing. Well, I take that back because Riverside County hasn't allowed us in their courtrooms. We appear telephonically, but in San Bernardino County, I still can go in person. So if the petition gets granted the day of the hearing, I will walk out with a signed order, and I can literally walk to the recorder's office, record that order, and that day my client is now the owner of the property. Like I mentioned, you end up in probate court, but this is not a probate transaction. The statutory attorney's fees do not apply. This is normally done on a flat fee or hourly basis. What about real property valued at or under 166,000 to 150,000? No, I am not crazy. I am familiar with the housing market in California. We will use this transaction. This is a summary probate transaction when there's no vesting. Or vesting is as tenants in common. How many of you have encountered a situation where there's 3 owners of the property, but one has passed away? So we need to probate his or her interest in the property, and vesting was as tenants in common. So remember, if it was as joint tenants, we wouldn't have this problem because we would just remove the deceased individual from title and proceed with the sale. But if vesting is as tenants in common and we're only probating in a certain part of the estate, it's very likely that we can use this procedure. Or when there's no vesting. I've had cases where a daughter will come into my office and she says, Georgina, we're in escrow to sell this property. My dad passed away 10 years ago, but I thought that we held title as joint tenants. I come to find out that there's no vesting. So if there's no vesting, the vesting is as tenants in common. So we have to probate the decedent's interest in the property. So with this procedure, if the property owned entirely by the decedent or whatever interest the decedent owned does not exceed 166,000 at the time of death, we can do a summary probate procedure. This is very important because sometimes people do not initiate probate until years have passed. I had a probate case where my client was incarcerated for about 35 years. So when he was released from prison, he's like, okay, well, my mom passed away. She had a house. I want to sell it because I don't have the ability to maintain that home. You know, I think a family member was paying the property taxes throughout the years just to be able to save the home because there wasn't a mortgage. So the family member was paying the insurance and the taxes. So this guy gets released from prison. His mom had passed away like 25 years ago. So I said, wait, maybe we can do a summary probate procedure. So I checked to see more or less how much the property was worth 25 years ago. And we met this threshold. It was under 166,000. So you're always looking at the time of death. So when you're in an escrow transaction or you're in a listing appointment and they tell you there's 3 of us, 1 passed away, and we held title as tenants in common, stop right there. You may not have to go through the entire full-blown probate so long as the decedent's ownership interest at the time of death was under 166,000. So when I say the decedent's interest, it can be 100%, 20%, 50%, we don't know. And so we need to have it appraised by a probate referee, which are appointed by the court. If they confirm that the property was worth under 166,000, it's a very fast procedure. We have the probate referee appraise the property. It takes them about 4 to 6 weeks. Then we confirm that at least 40 days have passed from the date of passing. We file the petition. The court date is set anywhere from 6 weeks to 4 months out. We send out notices. We attend the hearing. We obtain the signed certified copy of the order. We record it. The heir at law is now the owner of the property. So this is not a probate sale as we're doing this summary probate procedure. Your client is now the owner of the property. These are also done on a flat fee or hourly basis, so you don't have to worry about the statutory attorney fee. So this is the great thing about having these procedures available to you. The next option is a living trust. If someone passes away and they have a living trust and title is in the name of the living trust, you will avoid probate. However, title needs to reflect the name of the trust. So if the name of my trust is the GL Living Trust dated September 2012, when I pass away, my property, the last recorded deed, better have that name on the deed. If it doesn't, I'm going to have to go through the entire probate process. So you may encounter situations where the clients will tell you, realtor, don't worry, my parents had a living trust. Here it is. The living trust lists the property as an asset of the trust. Like I said, stay calm. Call your title officer or check title and confirm that the last recorded name is in the last recorded deed is in the name of the trust. Even if it's listed in the trust, you still will have to possibly go through probate. Living trust sales, if title is not in the name of the trust and there is a trust, there is a way to possibly avoid the full-blown probate, and that would be with a Higgstat petition. So the goal of the Higgstat petition is to transfer ownership of the property into the name of the trust. You're informing the court, Your Honor, husband and wife passed away, they had a trust, but for whatever reason, title of the trust is still in the name of the individual people, so we need to transfer ownership into the name of the trust. This petition is not guaranteed. There are certain cases where the judge will deny the petition, and even though there's a trust, you're going to have to go through the full-blown probate. So what is the judge going to look for? A schedule of assets. Is the property in question, the one that you're trying to sell, listed on the schedule of assets? If it is, then that's a slam dunk case. The judge will transfer ownership into the name of the trust. Or if there's a general assignment, if there's language in the trust indicating that the trustor indicates all the property that I own at the time of my passing, if it's real property, it's part of my trust. Or if there's a specific distribution, does the trust specifically grant the property in question to a certain individual? And then other facts. Do you have a signed, unrecorded copy of the deed transferring ownership into the name of the trust? So if you find the trust and you come across the original deed transferring ownership into the name of the trust, go ahead and record that deed. You can avoid the full-blown probate. You would be surprised how many clients come into my office. They have the trust, title is not in the name of the trust, but they know that the parents signed the deed, maybe because they have the copy. So if they have the copy, I tell them, well, this was never recorded. The original must be out there somewhere. So then they turn their house upside down and they miraculously find the original deed. So if you find the original deed, you can record it, transfer ownership into the name of the trust. You can avoid the full-blown probate. If you simply have a copy of the deed, that would not be enough, because you cannot record a copy of the deed. It would be a good argument to present to the judge, but it wouldn't work. What is the procedure? We file the Hegstat petition. The hearing is set anywhere from 2 to 4 months. You serve the heirs at law. You attend the hearing. Assuming the judge granted your petition, we record the certified order and the trust is now the owner of the property. This is not a probate transaction, even though we were in and out of probate court. Tips for handling trust sales. Make sure the trustee obtains an appraisal report prior to selling the property, or at least gets the consent of all the beneficiaries concerning the sales price. Because if the trustee just goes and sells the property and then everyone comes to find out that they undersold the property, they're going to be liable for the trust. So obviously, if you have an appraisal report, the sales price is within that range, you're able to prove that you did not undersell the home. On the other hand, if we send out notices to all the beneficiaries informing them of the sales price and no one objects, then we're good to go. And then have them consult with an attorney, because there are statutory notices that need to be sent out to all the beneficiaries. There are assessor forms that need to be completed, namely the parent-child exclusion. I think a lot of people forget when they're selling properties in the name of the trust to complete the parent-child exclusion. As a reminder, whenever a parent transfers property to a child, whether it be in life or after their passing, the property may be reassessed for property tax purposes. However, there's an exemption. There's a parent-child exclusion. If the property is being transferred from a parent to a child, it will not get reassessed. However, give me 1 second. So then in order to prevent the property from being reassessed, we need to complete the parent-child exclusion before the trust sells the property to a third party. Even though the children were never formally on title, the second the parents passed away, they are now the owners of the property, but obviously it's owned with the trust. So now the good stuff. Let's go through the full-blown probate. We discuss so we discussed affidavit of death of joint tenancy. That would be if there is a surviving joint owner or husband and wife with the right of survivorship. And then the spousal property petition. And then also if property is valued under 166,000. So with the full-blown probate, if none of the above procedures work, we have to go through the court process of getting someone appointed as a personal representative to be able to sign your listing agreement, and then accept an offer and move forward with escrow. So what is step number one? Step number one is someone needs to file the petition to get appointed as a personal representative. And if there is a will, then get that will admitted into probate. You as realtors should be familiar with these terms. If there is a will, then that person, your client, is the executor. But like I mentioned earlier, even though you have a will, you still have to get the judge to admit that will into probate and give your client the authority to act. If there's no will, your client is the administrator. If you don't want to get confused as to what term to use, just use personal representative, because a lot of times I come across clients or realtors that they'll confuse these terms. Just remember, if there is a will, then that person is the executor. If there's no will, then that person is the administrator. In California, the probate code dictates who has priority to get appointed as the personal representative. Obviously, if there is a will, the person named as executor has the right to get appointed. If there's no will, first it's a surviving spouse, then the children and the grandchildren, and so on. If there are individuals of the same degree that are fighting to get appointed, let's say there's 2 or 3 children all filing petitions, the court will have a hearing to determine who's going to get appointed. But I think most of the time they're going to recommend that the parties reach an agreement so you can avoid that expense and time of going through court. Step 2, after we have filed the petition, when we file the petition, a hearing date gets assigned to your court case. After we file the petitions, we need to send out the notices to all the interested parties. We need to publish it in the newspaper that we have initiated this probate proceeding. Prior to the hearing, we check what's called the probate notes to see if the court requires any additional information. Step number 3, the appointment hearing. If there's no objection and everything was done properly, then the personal representative will get appointed as the personal representative. They're given the title of executor or administrator. At that hearing, the judge will determine if they have full authority or limited authority. And this affects you as realtors in the sale of the home and whether bond needs to be posted or it does not. The probate order, I listed the form here. The order appoints the petitioner, the client, as a personal representative. They're given the title. It indicates whether bond will be required. The order is not the document that gives your client the authority to sell. This just reflects what happened in court. This is a cutout of the order. Where it lists your client's name, whether your client is the executor or the administrator, whether you have full or limited authority, and whether bond is required. The letters of administration is a single-page document. This is the one that gives your client the authority to sell the property, sign your listing agreement, and so on. You will need a certified copy at the time of sale. The appointment does not become effective until letters have issued. If the client is required to post bond, the letters will not issue until bond has been posted. What is bond? Bond is like an insurance to protect the beneficiaries or the heirs in case the personal representative runs off with everyone's money. In some cases, the court does require bond. In other cases, they don't. So just know, if bond is required, the bond needs to be posted prior to the letters being issued. This is a cutout of the letters. This is a document you should be looking at when your client approaches you, telling you they have a probate and they're ready to sell. So selling the property, what should you be concerned of as a listing agent? First and foremost, your listing agreement can only be for 90 days. If you have a listing agreement for a year, 6 months, it expires at the end of the 90 days. Pursuant to the California Probate Code, the probate listing agreement can only be for 90 days. So I know a lot of realtors have their clients sign the listing agreement prior to them even getting appointed, prior to the letters being issued. So in all reality, the clients can actually get out of the contract, because pursuant to the probate code, after 90 days, that listing agreement is void. First, I would argue that you have an invalid listing agreement because your client signed it when they didn't have the authority to sign it. And even assuming that it is a valid listing agreement, after 90 days, it's void. Obviously, it can be renewed for an additional term of 90 days, not to exceed 270 days. With the listing agreement, you're going to use your normal residential listing agreement, but you're going to add the probate listing addendum and advisory, the representative capacity signature disclosure form. Some counties have restrictions on commission. So in LA, if it's if the client has limited authority, the commission is capped at 5%. Here is a cutout of the listing agreement. I get questions, well, Georgina, how should I fill this out? The seller is the estate of Billy Jones. If Jane is a personal representative, she's not the seller. The seller is the estate of Billy Jones. Then you will mark this box that it's being sold as part of the probate. The 90 days, I put it down here, but obviously it goes up here in the date section just to remind you that it can only be for 90 days. This is a representative capacity signature disclosure form, which indicates that your client is signing on behalf of an estate. This is an addendum to the listing agreement. Again, the seller is the estate of Billy Jones. You're going to mark this box that it's a probate with a case number. When your client signs, they're literally going to sign their name, and then they're going to print their name and they're going to list their title. So what is the difference between selling a property if your client has full authority or limited authority? Obviously, you're going to prefer full authority. This is much faster. So if you're representing a buyer and you're submitting an offer on a property that has full authority, it's like any normal transaction. The time frames will be the same, so you don't need to worry about that. So let's go through the steps. If the client has full authority, you're going to list the property for sale and market it like you would have in any normal transaction. However, you're going to confirm that your client has been appointed and the letters have been issued. You're going to receive offers. Those offers, you're going to present them to your client. You're either going to counter or accept an offer at any amount. Obviously, you cannot undersell the property, but there's no restriction as to what the minimum sales price has to be compared to limited authority. So with full authority, obviously, you cannot undersell the property, but there is no restriction on the sales price. You open up escrow. The EMD will be any amount that you normally are accustomed to. The buyer conducts their inspections. At least 15 days prior to the close of escrow, I send out what's called a notice of proposed action. In the notice of proposed action, I inform all the beneficiaries or the heirs of the proposed sale. We inform them escrow has been open. This are the terms of the sale. If you have an objection, you need to sign this document and present it to the attorney. Or you can consent to the sale and return the document to the attorney. Or you can do nothing. If they do nothing, their lack of action will be treated as a consent, as if they consented to the sale terms. Then escrow closes. So in this, with full authority, the only difference is we need to send out notice of proposed action to everyone at least 15 days prior to the close of escrow to see if anyone's going to object. If no one objects, you're good to go. Escrow cannot close under 15 days unless waivers are signed by all the beneficiaries agreeing for the close of escrow to take to be within, I don't know, sooner, 7 days or so. If someone does object, then we have to proceed with the limited authority procedure. Normally in my practice, if someone does object, I do call them and ask them why they're objecting. If it's a couple $1,000s that they're complaining about, I explain to them that if we go through the limited authority process, we're going to end up spending more money. So it would be best just to sell it now. So just a quick recap. If your client has full authority, only difference is you need a certified copy of the letters to sell, and the notices get sent out at least 15 days prior to the close of escrow. So long as no one objects, you're able to proceed with the sale. A beneficiary has three options. Either they object, they consent, or they do nothing. If they do nothing, it's going to be treated as a consent. On the other hand, if your client has limited authority, you're in for a ride. First and foremost, the property needs to get appraised by the probate referee. The probate referee will tell us what the value of the property is. Then we have to publish it in the newspaper that the property is going to be sold. We list the property for sale and we market it once we have received the value from the probate referee. We counter or accept an offer within 90% of the appraised value. This is one of the main differences between full and limited authority. With limited authority, the court will not approve a sale if it's not within 90% of the appraised value. You open up escrow, the EMD needs to be the amount published in the newspaper. Buyer conducts their inspections. We file the petition for the court to approve the sale. We attend the hearing. We obtain a certified copy of the order and we close escrow. So with this procedure, with the limited authority, it's probably going to take about 4 months to finalize the process. And that's about it. So at the hearing for limited authority, someone can show up and submit an overbid. Here's a cutout of the probate purchase agreement where it indicates if court confirmation of the sale is required, then the close of escrow will be 10 days after escrow receiving the certified copy of the order confirming the sale. This, in paragraph 4 of the purchase agreement, you should be aware that it gives the buyer the opportunity to cancel the transaction if first the client had full authority and then someone objects and you have to go through court confirmation. The court is not going to tie down a buyer and force them to go through the entire court process. So if you're representing a buyer, first it was full authority and a beneficiary objected to the sale and you have to go through the court process, the buyer can cancel the transaction and receive their deposit back even though they have removed their contingencies. So what documents do you need to close escrow? If your client has full authority, you need a certified copy of the letters, the notice of proposed action, and the letter from the attorney indicating that there's no objections. If the client has limited authority, you need a certified copy of the court order and the letters of administration. So that basically covers it all. I know it's a bit confusing. It's a lot of material to take in. So does anyone have any questions? I guess you can submit them in the chat. Joyce, if a couple purchased a house 10 years ago during their marriage, but the title is under the husband's name only, they both have kids from their previous marriages. If husband passed, is it a probate? Who will get the property? In this case, it's a bit complicated. Obviously, the house was bought during marriage, so you're probably thinking about the spousal property petition, which is great. Shows that you're paying attention. So in that case, I would attempt to proceed with the spousal property petition, but since it's a blended family, the children of the husband can actually contest this petition and argue that it's not a community asset, that the assets to purchase the home were acquired before marriage. Also, you need to ask if there is a will. If there is a will indicating that the house goes to wife, then that would resolve that issue. What if there's a loan on the property? You take the property subject to the loan. Sometimes, you know, if it's the wife inheriting the property, I don't think the lender will call the note payable, but they will definitely not release any information unless a probate proceeding has been initiated or there is a trust. I will send a copy of the PowerPoint to your board, and I think they are recording this presentation. I'm not entirely sure, but I think it is being recorded. What other questions do you have? Betsy, what situations does the court ask for bond? Bond requires for administrator cases only. So what I've noticed is that in San Bernardino County, if there's no will that waives the bond, the court is going to require bond. There is a document that all the heirs can sign indicating that they waive the requirement of the personal representative to post bond. But even in San Bernardino County, I've had everyone sign it and the court still orders bond. In LA County, they're a little bit more lenient. So if everyone signs the waiver, they're not going to order the personal representative to post bond. If the buyer can't get the loan, can he back out of the probate? It's like any other normal transaction. It depends if they have their loan contingency in place. So if the buyer has their loan contingency in place and they can't get the loan, then they can cancel the transaction using that contingency. But if they have removed their loan contingency and they cancel, then they forfeit their earnest money deposit. Jose, I understand that credit scores or debt was not a factor, including spouse on title. For example, if a spouse is not working, she can be included on title. Yes, so every case is different. You know, some lenders will indicate, well, if your wife is on title, that means she's on the loan and you can get a better rate if she's not on the loan. There can be numerous reasons why the spouse isn't on title. I just gave a few examples. So yeah, there's several reasons why the spouse isn't on title. Liliana, I currently have a client whose mother passed away. There is a trust. He is in the trust. There is a loan. He's the only son, no husband. What do you recommend? He would need to set up a consultation with my office to go over the trust and review the trust to make sure that what you're telling me is in there. If there is a loan, normally he can contact the lender and tell them, my mom passed away, here's a trust, here's a death certificate, I'm the trustee, and they'll release information to your client. Joyce, when will be the best time to take a probate listing since the term is 90 days? As soon as your client gets appointed, if anything, it can be extended for another 90 days. Amy, if a property was purchased after marriage and is under only the spouse's name, can we proceed with a standard sale? Are there any documentations need to be obtained? Amy, I'm confused. Is the spouse deceased? Or are both spouses still alive? So please clarify for your question.
She can unmute herself and ask the question if she wants.
Okay. Sharon, will there any differences show on title after record affidavit of death? Yes, after you record the affidavit of death, it's going to show that the surviving joint tenant is now the owner of the property. Is 5% a law? Yes, for residential properties in LA County, if you have limited authority, it's 5%. For land, some counties vary. Some it's 7, others 10. So you need to look specifically at the county that you're dealing with. How do we know if title is trust or not? You need to look at title. Look at the last recorded deed. Call your title officer.
Can I clarify my last question? Because on the title, it shows LLC and the owner claims that they only owns a portion of the LLC. So how do we know if
so your client claims that he only owns a percentage of the LLC?
Yes.
So you have to look at the operating agreement for the LLC. And you need to look at the previously recorded deeds, because sometimes there are two owners on a property and one transfers his ownership interest into his or her LLC.
Okay, let's say if I'm the LLC manager and one of our member transfer the title from his name to the trust after
This is, this is getting very complicated, because normally when you have a trust and you have an LLC, title is in the name of the LLC, and then there's an assignment assigning your interest in the LLC to the trust. So I really don't know what the client did. They're free to schedule a consultation with my office, but what I suggest you do is call your title officer, look at the chain of title to see what deeds had been recorded, and go from there.
Okay, thank you.
You're welcome. Any other questions? And Amy, I never got clarification. I think you said yes, assuming the other spouse is deceased. So if title is just in one spouse's name and the other one passed away, yes, you can proceed with the sale, assuming none of the adult children of the deceased spouse have filed a claim to initiate probate for that property, because maybe they're going to claim that the deceased spouse had an ownership interest. All right, any other questions? No, I think that's it. So for the commission question, that's total. So 5% for residential property total. If it was 5 for each side, that would be 10% for residential property. That would be way too much. All right, anything else? Nothing else?
Thank you, Georgina.
All right, well, it was nice seeing everyone. Take care.
Okay, bye.
Bye.